Well, good afternoon again. We're going to execute a small change in our schedule. Some of our brainiest folk are going to be leaving slightly early, so we have quite a number of questions that were prepared this afternoon, so we don't have answers prepared in advance, and so before we lose our brain power, we wanted to go ahead and answer those questions. After we're done with those sticky note questions, we will I'll talk to you about corrective action plans, and then we'll return to a Q&A format in order to answer the questions that we received before today, for which we have prepared answers and don't need any more brains.
Thanks, David, and thank you all for staying with us and staying attentive during this long day. I hope it's been helpful, and I've certainly learned a lot. And so we have some questions, and I'll try to decipher the handwriting and read these, and hopefully we'll even know some of the answers. First question, when do you anticipate HUD will adopt the 2010 ADA/ABA guidelines? When they do, what will that mean for new and renovated 504 properties?
At least by 2020.
So,
I'm kidding. We are in the middle of a review on this. We hope to have a final announcement of that soon. In the meantime, you'll follow what you currently follow, including UFAS. Once those standards go into effect, there'll be an effective date, and they'll apply as designated in the requirements to properties constructed after that date. I'll also mention, while I have you here, that more imminently than that is a plan between HUD and the United States Department of Justice to issue a joint statement on design and construction issues, answering a whole series of questions that have come up about accessibility under the Fair Housing Act. While I can't give you a precise date for that, you should be watching for it within the next 2 months. And that will be posted once it is issued on DOJ's website and on HUD's website, and it'll begin getting wide distribution.
So a related question or a specific application of this issue on the 2010 ADA guidelines and supplanting the 504 rules, does that mean that new or renovated 504 properties will have to provide pool accessibility, i.e. a means of entry and exit into the pool?
Well, because the standard hasn't been finalized yet, I can't answer that question. What I would say in general is if you're looking to develop something from scratch, starting sometime after the next 2 or 3 months, you ought to be looking at plans that provide that as an option, but I don't know what the standard will ultimately provide for. Certainly, as I mentioned earlier, the Fair Housing Act only requires access to the deck of the pool, not into the pool.
Does HUD have an internal contact that folks can use as a resource to answer questions?
Yes. I have a staff member, Cheryl Kent, K-E-N-T, who is the designated point of contact on all of these standards and the Fair Housing Act accessibility requirements. And she and her supervisor, Lynn Grasso, and myself will consult as necessary on responses to questions. I'll just tell you that we should also use the Fair Housing First resource and the design manual and other resources, because we get a little crabby if we get calls about questions that are clearly already written down and they've been answered several times already. So if you've got a really challenging issue you don't know the answer to, bring it on if you've done your homework first. Thank you.
Yeah, and during the course of normal mortgage insurance processing, the protocol is to go to the HUD field office, and then to HUD headquarters. Technical support is the way to handle that, and often we can go ahead and give that answer, and that's
or
how
get
we'd
it from
handle
us
it.
or whatever is necessary.
So is FHA mortgage insurance considered federal assistance? And
No, it is not. Under HUD's Section 504 regulations, guarantee of insurance is not considered to be federal financial assistance in and of itself, although that's often part of a package with other things that are designated as HUD federal financial assistance, including Section 8, HOPWA, any of these other programs.
okay. So we actually, and that I think is a good lead into the question we got verbally and isn't on here, so hopefully I can restate it correctly. Supposing a project has a Fannie Mae loan, is it subject to all of the rules we've been talking about today?
Yes.
So,
And
so the answer is it depends.
well, it depends on all the things we've talked about which laws apply. I can tell you as someone who was outside counsel for Fannie Mae during a period before I came back to HUD, Fannie Mae took the position and did training for all of its inspectors for properties, multifamily properties, coming into its inventory, whether it was by purchase of a loan or by new granting of a loan, for accessibility requirements, in particular with Fannie Mae loans, the Fair Housing Act requirements, because a lot of their loans affect market rate housing specifically. So it is my understanding that Fannie is looking at that. But Fannie Mae loans per se are not considered federal financial assistance, maybe, but it doesn't matter because Fannie's still going to look at compliance with Fair Housing Act and other appropriate civil rights laws because it's a risk factor for them. They're not going to want to purchase the loan if the property could be subject to a lawsuit with multi-million-dollar judgments.
So if the property was built after 1991 and it had a Fannie Mae loan or a conventional loan or no loan, the Fair Housing Amendments Act requires fair
Correct.
housing accessibility, so it just doesn't matter. So the answer in that case is yes. If it was built before 1991 and there was no form of Section 8 or block grant assistance or home funds or anything like that, the answer would be no. It's not subject to fair housing accessibility or UFAS.
Great answer.
Okay. I actually don't know very much about this, but that's like the one thing I know. This next one, I don't know the answer, but I think it's a good question. And I'm going to rephrase it to not cast aspersion on other government entities who consider an answer to this political suicide, according to the questioner. But has HUD made a determination of the threshold for, quote, undue financial and administrative burden? And can we give an example that would be appropriate? And maybe just some context for what this question would be applied to. Undue financial and administrative burden,
Yep.
what does that apply to?
Well, going to answer the question, Larry?
No, I asked the question.
Undue financial and administrative hardship, there is some general definition if you bury through 3 HUD handbooks, something that cannot be restored to the operating reserves within a year. So, in other words, taking your profit, taking whatever money you've got left over that goes into your operating reserves, if it's so much money that you can't replace it in your operating reserves within a year, it might be considered financial hardship. I'll tell you that it's a very fact-specific question, depending on the circumstances, and that there is no uniform standard other than the one that I just mentioned. But I'll tell you that every case will be different, and that all of the resources of the overall developer or owner will be considered in determining undue financial and administrative hardship, not just the resources available to a particular property. Does that help?
That was what I was hoping you would get at, is that this is not a large window you can get through. This is more like a peephole that has very specific requirements for it, and it's not something that you can just sort of go there as you're out.
Yeah, well, let me just say, anybody who just announces that it would be an undue financial and administrative hardship is looking for a detailed investigation for the underlying rationale and costs burden. And I have not been able to think of more than 1 or 2 circumstances where that would be actually likely to apply. So your take on that is correct. It is a peephole, not a picture window.
Let me add that the new procedure that we've tried to lay out with corrective action plans and also in Appendix 3 to the proposed mortgagee letter is that the whole question of whether
Janine is here.
responding, creating a remedy is exempted or not by reason of a undue financial and administrative burden is not a decision or an assessment that a needs assessor can or should make in the field. It's one that has to be made by the lender after fact-finding with the owner, because it's a matter of historical record, investigation of the property, financial condition of the sponsor, and so forth.
Very good.
So, next question. A particular HUD office was approached with an application, and there was question about accessibility and conformance with respect to the blocking behind the bathroom walls to provide for grab bars. And the PCNA analyst provided both building plans that said the blocking was present, as well as the result of an analysis by their Black & Decker stud finder. And the HUD office didn't accept that in this case. They said, without being clear whether it was one unit or a sampling of units or all units, but they wanted them to do destructive testing to tear the walls out to make sure the blocking was there. Was that a case of overreach?
I would say yes, and I would also suggest that if there were a circumstance where there was sufficient doubt and no other means of detection is possible, it would not require removing drywall and so forth. A simple nail, small, finishing nail through the drywall will tell you whether there's wood there, and it's a relatively simple matter to spackle over the little hole, several little holes.
Okay. So there actually another question about destructive testing outside of the context of fair housing accessibility, which we're not going to deal with in this session since we're talking about accessibility requirements. But the answer there would be, unless there was something else going on that the field office wanted destructive testing, a set of plans and a stud finder would be adequate to demonstrate the presence of blocking in the walls. Next question is, are fair housing accessibility requirements triggered in the sub-rehab of a commercial historic building, and specifically it was a gut rehab down to the floors and studs?
No, and because the Fair Housing Act only applies to buildings designed and constructed for first occupancy after March 13th, 1991, and that's first occupancy for any purpose. So if you've got a historic building where there's a gut rehab, the only exception would be if there was such a gut rehab that what you did was tear down everything behind the facade and rebuild the entire property. Is that right, Kathy? Then that's covered because it's essentially new construction behind an old facade. But if what you're looking at is, something that leaves the structural elements and replaces the elevator and redoes the floors and all of that stuff. It's
well,
rehab,
it
not
goes
new
down
construction.
to the studs, though, so they are pulling out all of the drywall, but they're not changing the structural elements.
Not new construction.
Okay, that's the answer. What about hurricane damage areas with units built pre-1971 but got rehabbed following a hurricane?
I believe HUD has opined in at least one case that where the unit was completely destroyed down to the slab, that the rebuilding was essentially new construction. But where you're talking about essentially rehab where walls are still there and some structural elements are still there and you're rebuilding around it, that's not considered new construction.
Okay. What would the...
Just weigh in and say if it's after something like Katrina, there's likely to be federal financial assistance of some kind involved.
Which might require accessibility because it's renovation, often substantial renovation. It might require the 5% and the 2% of the units under Section 504, for example. Good point. Thank you, Janine. Janine Warden's out there in the audience, for those of you who can't see her.
Thanks, Janine.
Could I add to that question, particularly with respect to New Orleans and other similar locations? New or replacement housing is now required to be elevated.
Mm-hmm.
Have we had situations where we've established how we will manage accessibility in those cases?
Yeah, the new requirements for elevation to avoid buildings being swept away by future floods do present some challenges in terms of accessibility. You can do platform lifts, which are permitted as part of an accessible route, preferably under cover, thank you very much, so they don't deteriorate out in the wind and the rain. Or you can do a ramp design with potentially with switchbacks to provide more accessibility. For single family, for multifamily, a lot of times what you're doing is you're putting parking spaces underneath and putting multifamily above it, in which case access via an elevator to units above the flood level would still provide for accessible units via the access through the elevator.
If I could pivot again, the Department of Justice has a consultant who is working on Katrina ADA matters, but also providing advice on Section 504 and Fair Housing Act under a contract with the Department of Justice, free consulting advice. And I don't have the email address available at the on the top of my head. I believe it's something like katrinaada@usdoj.gov, but I'd have to confirm what it is. If anyone is in the Katrina impacted areas and would like free consulting, it is available from the Department of Justice.
Last applicable question here that we received in the parking lot questions. What would be the requirements under UFAS, so we're assuming federal assistance, for 100% townhouse development that was built in 1970 and has no sleeping area or bathroom on the ground floor of the units?
Somebody out there in the audience want to take this one on? So what you got is federal financial assistance, townhouse development, UFAS, built in 1970. Didn't comply with UFAS at that time, apparently, because it's got
No sleeping area?
1970 would be before UFAS went into effect.
Can I suggest that we actually answered this question in advance? It was one of also the prepared answers. So let's rely
Okay.
on that. And there are also some very specific circumstances that perhaps should be discussed offline.
Okay. That is it for the written questions we received on the parking lot. Before we say goodbye to Sarah and move on to the next segment, are there any other questions from the audience? Craig?
Sometimes when I'm doing evaluations of properties, the units that I'll select to be converted for UFAS, where they don't meet completely, but they have a certain percentage of units, often 202s and whatnot, that have that old 202 percentage, usually 10%. And they'll have varying degrees of compliance already. Those are usually the units that I would select to convert furthermore into fully converted.
Craig, I'm sorry. Would you mind repeating the question? I was going to try and take a stab at repeating it, but as long as you've got a mic, go ahead.
What I was saying is when I'm doing an evaluation, particularly with 202s and projects that already have apartments that have some level of compliance, those would be the units that would be selected by me to try to take them to full compliance. Is that something that you see regularly and that's acceptable? I mean, the field offices seem to be fine with that. Usually they're spread out fairly.
I can tell you that HUD took a similar approach in a consent decree or conciliation agreement involving a large public housing authority, which had a lot of older, smaller units that were not necessarily very accessible and required them to be updated to be fully accessible. In at least some of the buildings, it was actually necessary to take 2 zero-bedroom units and combine them to make one fully accessible one-bedroom unit, and that was one strategy that they used. There are some challenges in retrofits to get to full compliance on those settings, but the question is really whether you can get to full compliance in whatever you do. The only thing I would say in addition to that is make sure that you're, when you're looking at that, you're looking at getting a range of unit types fully accessible. So if the property has 3 bedrooms, you may have to use some unusual strategies to get that, and 2 bathrooms, for example, you might have to use some unusual strategies to get them fully compliant, but you need to do that, of
And
course.
that's really the only drawback that I ever see is that sometimes they select all 1 bedrooms to be the ones for whatever reason. I do find that
Right.
periodically. So in that case, you would recommend going ahead and taking a 2 or 3 as well.
Yes.
Even
I
if
think your
there's zero
unit types, especially even in renovations, if you can get a range of unit types to be fully accessible, I think that's what UFAS, and what a transition plan would have required in 1989 and what, we would be looking for today.
Any other questions? Question there? Holly, hold on though till we bring the mic over so we don't have to repeat it.
Thank you.
In bringing an older building to compliance, I was told that the plumbing on the tub has to be moved from the end of the tub to the middle of the tub. And is that true?
Was there a rationale for this?
That it was easier for the person who was handicapped to reach the dials.
You're talking about moving the tub control from the center of the tub to the side, toward the outside of the tub.
Right.
Yeah, I understood what she was asking, but I don't know what the rationale for that would be.
No, it was like the pictures that we just saw, which made me think of that it was an issue
Whether that's a requirement.
or a misunderstanding.
It doesn't appear that that's a requirement under federal laws. It could be a state or local law. And it occurs to me, you know, I'm not particularly disabled, but I am particularly middle-aged. And actually, if I was designing it, now that you mention it, I'd put it on the side.
It is in UFAS, it's not in fair housing.
It's in
Okay.
UFAS?
UFAS says that the controls for the tub should not be centered on the tub, it should be towards the outside of the tub, so the person in a wheelchair doesn't have to reach so far over. And the concern they had when they put that in was that a lot of times the toilet is next to the tub, and so you can't get the wheelchair maneuvered
To close enough, and you might turn on the water and it's all hot and scald you or something.
that's a little closer to the outside. That was the logic behind it.
Interesting.
Okay, so for the benefit for the people on webcast, the comment was made by one industry participant observer that UFAS does require for those accessible units to have a different location for the controls. Okay. Any last questions? Okay, we do have prepared questions and answers that we'll go through in a little bit. And again, there are some questions on other aspects of the PCNA analysis that we'll be deferring. Happy to chat with the individuals after the session. This is really about accessibility.
Thank you, everybody.
Thank you, Sarah. So, are you going to do the corrective action? Okay, so you're just going to feed right into it. Thanks so much.
Okay, we are now going to spend a few minutes talking about corrective action plans. And for those of you who are here in person, you may have brought with you 3 worksheets, all part of a single spreadsheet, that were labeled a draft format for a collective action plan. And that's what we're going to be referring to here. And there are multiple copies of it outside the door if you didn't get one. Okay, so what we want to do with a corrective action plan is we want to identify each deficiency. And we want to describe the physical remedies for that deficiency. We want to estimate the cost for implementing those remedies, and we want to set a specific schedule for getting the job done. And that time frame is as fast as possible. And if after all the participants have worked as hard as they can to get the schedule as short as possible, it still takes more than a year, then we're going to ask you to send it up to headquarters, either to Mr. Sullivan or to Mark Van Kirk, if it happens to be a 10-year update PCNA through asset management. Now, the reason we're doing that, by the way, is because as we said earlier, the class of repairs that address accessibility issues are essentially regulated by, statute. And usually if we have a problem, it's because we've already run through the red light. And as I said, it requires immediate attention. So some of you may think, well, golly, here we go with another form, another exhibit, and why do we have to do that? PCNAs now usually are a 150 to 250, maybe even 300-page document. And usually it has most of what we need to know about accessibility problems, but not always. But often that information is scattered through the document. I don't mean to say that the author is disorderly, but it's just the way he organizes the document. We don't see everything in one place. Accessibility remedies, as I say, are different from other repairs because they're required by statute. They have different timelines, and the review of these issues may require special expertise. So we want to facilitate responding and getting early decisions by presenting this information in a detachable form. This will make it easier for field offices and for headquarters to review when we have special cases or transactions that require special attention. And if we wind up having to take them to fair housing and equal opportunity, either for a legal or a technical sort of review, we will have a relatively short document that we can send to them rather than trying to ship them a 350 or 300-page PCNA that they may spend an entire day or two trying to identify where the correct information is. So the other thing that's true about putting all this information in a corrective action plan is that it creates a clear record. And if I were an owner, that's exactly what I would want. I would want to be able to show a plaintiff, a judge, my counsel, that I had documented all the things that I needed to do in order to comply with these statutes, even after I had messed up at the outset. So in addition to that, if there's a circumstance that prevents me from full compliance, I want to have documentation about why that is so. And as we've said before, corrective action plans are not a safe harbor. They can't stop anyone from suing you. But if I were in that situation, I would consider an approved, accepted corrective action plan the next best thing. Now, if you look at the spreadsheet pages that we gave you, I want to start with the third page first, because it's really the meat of the matter. And if you look under column A, what we want you to do is identify each deficiency by the statutory requirement or the UFAS citation or the ADA standard citation that governs that particular issue. And a reasonable arrangement of this would be to list each set of remedies or deficiencies rather under the item, the requirement that the property fails to meet. So in this particular example, we have a threshold problem. So that's Fair Housing Act Requirement 4, a requirement for an accessible route into and through units. And so we have a primary entry door where the threshold is over 3 inches and doesn't have 3/4 of an inch and does not have the proper slope. So we're going to replace these thresholds. Well, maybe there's more than one. Maybe we have 22 or 30 or so entries that are like this, and maybe they're all the same. So we're not going to ask that you list 22 or 32 different doors, just the same deficiency, and we'll quantify that further to the right on the spreadsheet. Now, but each deficiency, we'd like you to give it a number so we can keep track of these things, and so you can keep track of them as well. And so in reviewing them, we can discuss them with one another by a specific reference. The next columns are B and C. We want you to use a lot of photos. Photos are easy to do these days. They're easy to transport. You don't have to print them. You just attach them, give them a number. You can give them a label as well, tell us what it is, but we want a number that identifies that photo along with the numbered deficiency. In addition, we want you to tell us where the deficiency is located. And you can do this in a variety of ways, depending upon the exact circumstance. But in the most common cases, like this threshold, you're going to have a series of buildings, a phase 1 or a phase 2, or some other description of the location. In this case, I think we said all the entries in buildings 2, 3, 4, 5, and 6. Then we want you to tell us what the remedy for this deficiency is or might be. We want you to describe this succinctly, but with sufficient detail that it could be used to estimate the cost, and it could also be used to for an inspector to go back and verify that the remedy was completed. So if it's a more complex problem and has 5 or 6 or 7 or 8 different steps to it, then list all the steps. And then, of course, you want to quantify it. This is fairly straightforward. It's five thresholds. It's 5 each, $50 each, and that includes labor. And so it's an extended total of $250. I'm keeping this simple, but you can see how it might get a lot more complicated if you were doing the remodeling of a bathroom instead of merely the replacement of a threshold. And then we want to know how long this is going to take. And we're measuring this, since we can't assign a specific dates to this because we don't know when closing might be. We don't even know if the transaction will actually happen. So we have date of closing, whenever it happens, is 0. And so if it's going to be done before closing, then what we enter here is 0. If it's going to happen after closing, we want to know how long, in days. And when you're doing this, you will want to contemplate it as a construction project. So we're not going to string together continuous periods of 5 days here and 6 days there and so forth. We want to know the number of days from the date of closing when this particular item will be fixed. And so if this will not be a column that adds, for example. So you won't add it up at the bottom and get the total number of days it's going to take. You might get the total number of man days or something, but it will not be elapsed time. Everybody with me on that? So what we'll see then is we'll go through this list, and we will see maybe one item's out to 240 days. It's probably fairly complicated. It's probably the remodeling of several dozen bathrooms, in which case we'll be thinking about, well, we're not to 365 days yet, so it looks like we're good to go. And assuming that the lender and the owner are telling us that this is as fast as it can be done, I think everyone will be happy. Then you may have some other exhibits. For example, if you are remodeling bathrooms, you might actually have a drawing of what that new bathroom is supposed to look like, or how you may have a before and after drawing that shows the existing bathroom, and the architect may, or the designer, may identify where the toilet's going to be moved to, or where whatever's going to change. You may want to show that on a drawing. And if that's what you've done and it makes sense, then you want to attach that also as an exhibit and number it. Okay, let's go to page 2, the middle page of the spreadsheet. And really what this part of the spreadsheet is about is deciding what buildings are covered. And what this is really about, for the most part, is when was it built? Now, most of the time, the answer is going to be very easy, because it's going to be built in 2005, in which case we know that the fair housing light switch is on, right? And it stays on. Or it might be built in 1980, in which case we know the Fair Housing Act light switch is off, stays off. And so the only reason we're doing this form is because it's a sister or it has some other problem related to 504 or ADA. So there might be a case, though, where somebody tells you, the lender tells you that, oh, it's built in 1991. Well, when in 1991? And what do we mean it was built? You mean it was occupied? You mean we got a building permit? What do you mean? So then you have to get more precise, because there is in fact, and there were in fact some projects that on March 14th, 1991, got an occupancy permit, so then you wonder, well, is this in or out? So I think the specifics Melissa and Kathleen went through this morning during the legal presentation, but essentially if you got a building permit, let's see, after June 15th, 1990, or if you had first occupancy with a tenant moving in, CO, and so forth, after March 13th, 1991, then you are subject to the Fair Housing Act. Did I get that right? I think so. You have a similar issue with, well, we're going to go further across the page here, because we're going to make a decision. Either the Fair Housing Act switch is on or it's off. If it's on, we put an X in the box. If it's off, it doesn't apply. We don't have to fill out the rest of this.
David?
Yes?
In the spirit of avoiding acronyms wherever possible, on the previous slide, it might be good to spell out Fair Housing Act instead of saying FHA applies. Previous.
There?
Right. Upper left-hand column, FHA applies, what does that mean?
Well, it means Fair Housing Act applies
Got
is
it.
what I meant, but
So we'll spell
have
that
to-
out
I mean,
on the final version.
I thought in the context everyone would know, but we'll see. Okay. At the bottom of this page, we're looking at the Rehabilitation Act of 1973, essentially the same process because we have a timeline that's important. So if this project was assisted when it was built, say in 1977, then certain things are true. The rheostat switch is on, but it may not be at full power. So we know we're going to have some more difficult issues to deal with. Or maybe it was built with assistance in 1989 or 1990, in which case it should be built to the new construction standards under 24 CFR 8.22, and the standard that you're looking at when you walk through the building is that switch needs to be all the way on. If it's not, it's a deficiency. So we go through the same process here. We want to know what type of building it is, the total number of units, and we want to know what's 5% of that. That's fairly easy. What's required, and then what we actually have. So when a project is built either before the effective date of the 504 regulations, or it becomes assisted after it was built, we may have some uncertainty about where that rheostat switch should be. So what we're asking the needs assessor to do is to look at these properties in light of the new construction standard, so that we know where we are. And that's the information that the lender receives from the needs assessor. And so there may be an iterative process required here of back and forth. But the only group that's going to know where that rheostat switch should be is the owner and the lender after discussion with the owner. Because some of the history of the property may not be known to the needs assessor. So we don't want needs assessors out in the field making assumptions about administrative and financial burdens. They can certainly identify bearing walls, and those might be relevant. But what we've seen heretofore are, in a lot of these cases with assisted housing, is the needs assessor essentially being told by the lender to give me the answers, and the needs assessor attempting to make assessments of whether something is realistic financially, or whether it's feasible financially and so forth. And these are not questions that are appropriate for the due diligence third party to resolve. They have to be resolved by the lender. So first, as I said, we want the needs assessor to note in the physical inspection report how this assisted property would stand up against the new construction standards. Then we want the lender to review that, and then we want a recommendation about how the actual condition of the property compares to where we think that property should be on that rheostat switch. And the difference between those is what we're going to identify as deficiencies, and those need to be addressed. So there are a couple of other things that the lender has to do and should be done in advance. One of the things is that we really need to know whether the property is assisted or not. There's no reason to think that the needs assessor will know that in advance. He might, but the people that should know and should advise the needs assessor of the facts are the lender. Here I go. Yeah. Lender provided info. Is this property currently insured? What section of the Act are we going to use? And is it federally assisted? And I think that's about it. Now, this is a draft format. It's set up in Excel. It's not terribly complicated. It doesn't have a lot of calculations. It's intended that lenders will and needs assessors will incorporate this into their existing software apparatus for managing their work, and that there may be some better ideas on how to display it. But that's the content that we want, and we want it severable so that it can be easily pulled apart and reviewed separately. And that's pretty much it.
Marcy, did you have a question?
Yeah, will you attach this to Exhibit A of the FHA commitment?
So the question was, would we attach the critical corrective action plan to the firm commitment? And the answer is it would be part of the scope of work. So yes, this would be an exhibit. It's really part of the PCNA scope of work. It's just a separate listing for fair housing purposes. And the answer is, so the second question is a good one, and it applies actually more broadly. And the question is, will it go to asset management? And the process of transition from development to asset management has been uneven through the HUD offices, and I would observe in every other financial institution on the planet. It's hard to do this. We are actually working with asset management on a number of fronts on that transition, but specifically they helped us develop the PCNA scope of work and the PCNA mortgagee letter, and so we do anticipate continuing to work closely with asset management in that transition. We acknowledge it's not a perfect system, but that's the idea.
I'm going to retreat just a moment and pick up some written questions that we had received by email prior to today's training, where we have some prepared answers, and we'll deal with those.
While he does that, I just wanted to say thank you to the people that helped put this together today, and specifically Sylvia Chapman and Rita Simmons and John Bell for varying roles in supporting the effort, as well as David Wilderman and Jack Malgeri, who were the driving force and brains of the outfit, and likewise Sarah Pratt and Kathleen Pennington, Janine Worden, Janine Velez, and Melissa Stegman, all of whom are very fine lawyers who we're glad we have on our staff. And I probably missed someone, but those are the ones that I was aware of in the meetings. David, do you have the written questions, and how do you want to handle this?
Well, some of the answers are a little lengthy, but I will try to redact them.
Okay. Do you want to split them and have me handle some, or do you want to just handle them?
That will be fine. I think, is this still on?
Okay. So who drafted the answers here?
An undisclosed team of attorneys.
So these are somewhat long, and I'm just wondering if we need to go through all of these in detail and rather could post them on a website. What do you think?
We could do that.
So let me just go through the questions, and if anybody wants to make some comments. Some of them are, literally 3 paragraphs that I don't want to just sit here and read. But let me just read the questions. If there's any difference, is there any difference in fair housing and ADA requirements for apartments versus assisted living facilities and nursing homes?
The short answer is yes.
Yeah. The longer answer is this is a complex question that goes beyond the scope of this training, and then 3 paragraphs of commentary which we will post on the internet. Next.
Next question is the date for use of the 2010 ADA standards was 3/15/2012. In assisted projects where UFAS and the new ADA standards are in conflict, which is to be used? And the answer is that the UFAS and the 2010 ADA standards may differ, but they do not conflict. And sometimes the ADA standards require greater accessibility, and sometimes UFAS requires greater accessibility. The general rule is that the standard which requires the greatest accessibility is the one that applies. And we'll post the more complex answer as well. Well, this is the one.
Did we already answer this?
No, this is the one we said we would answer at this point. So,
Go ahead, David. Look at this.
our assisted townhouses built before 7/11/1988 required to meet Section 504 and UFAS requirements. And the answer is, all housing which receives federal assistance is subject to Section 504 and our implementing regulations. The program, and this includes program accessibility. Program accessibility means that a program, well, it basically means that that rheostat switch, the owner is always pushing it toward a brighter, toward the highest you can get it, right? That's always the owner's responsibility. If you're not already there because you weren't built according to the new construction standards, then you have to keep pushing. Now, and if you're in a set of townhomes in a hilly area, and it's a relatively small project, and we're not very financially, we don't have a lot of financial wherewithal, you may not be required to do very much. But you can't just shrug your shoulders and say, I don't have to do anything. That's the short answer.
Next one is, does receipt of Section 8 rental subsidies alone trigger any fair housing or ADA requirements? And the answer to that is no. Neither Fair Housing Act requirements nor ADA requirements for housing are triggered by receipt of federal assistance, including Section 8. Receipt of federal assistance, however, triggers Section 504. Federal financial assistance is broadly defined under HUD Section 504 regs. Examples include, but are not limited to, funding under the Section 811 program, 202 program, project-based rental assistance, tax credit assistance, home program, HOPWA, CDBG, neighborhood stabilization program. Many housing developments involving project-based rental assistance or other types of federal financial assistance are also covered by ADA and/or Fair Housing Act, and to answer in more precision would be a case-by-case analysis. And I'll take this one just because we get this a lot. I get this a lot. If a project was designed to comply but was not built to plan, is there a grace period after construction to allow for compliance? So someone who's not a lawyer or an architect, give me the answer to that one.
No.
The answer is no. There is no grace period for compliance which is required at the time of design and construction. However, when deficiencies are found in the process of underwriting a transaction, a corrective action plan must propose a workable and reasonable remedy, including the time required for completion, which must always be the most expeditious schedule possible. Court decisions and/or settlements have set time limits or schedules for specific circumstances of particular cases where litigation is occurred, but you can't extrapolate that into general application. So the rule here is as fast as possible. We expect it as a critical repair. If it's deferred, it should be done within 1 year of initial endorsement. And if it's going to be on that, it would need a headquarters waiver.
Another question, can the location of electrical environmental controls, which are only a little bit 1 inch off, be fixed on an as-needed basis like a reasonable modification? And the answer is no. The Fair Housing Act requires that accessibility be provided at the time of construction, not on an as-needed basis. Neither reasonable modifications under the Act, in which the resident pays to have some additional accessibility feature installed, or a reasonable accommodation under Section 504, in which the owner pays for a similar feature, are remedies for failure to comply with the fair housing design and construction requirements that existed at the time of construction. We note also that 1 inch is not a little bit when it comes to accessibility. For purposes of the PCNA, the needs assessor should report actual measurements observed in the field, and the lender should apply reasonable judgment when addressing the timing and substance of retrofits for electrical or environmental controls in a corrective action plan. I'll go ahead. Here's a related question. Actually, it goes to tolerances. And actually, this same question has been asked twice. Under the Fair Housing Act, are there tolerances or allowances for the precision of measurements? So if the clear floor area required is 30 inches by 48 inches, what about 30 by 47 plus or minus? The answer, no. There are no construction tolerances for compliance with the Act. Any tolerances are already incorporated into the accessibility guidelines and other safe harbors, so the needs assessor should report specific measurements, and the lender should exercise a reasonable judgment concerning the timing and substance of any remedies for slight noncompliance.
Do bathrooms serving a leasing office have to be accessible, and to what standard? And the answer is yes, they do need to be accessible. Leasing offices are covered by the Fair Housing Act, the American Disabilities Act, and in the case of assisted housing by Section 504. The leasing room, office restroom must comply with fair housing requirements, ADA, and again for assisted housing, UFAS. The 2010 ADA standards generally provide the greatest accessibility. So, and as I understand it, those will be implemented at some point in the future. Here's a question. Will the Q&A email box open for this event remain available after the training session? And the answer is yes. It was drafted until the dust settles, and I'm going to make a command level decision and say till June 1st when we're cutting off accepting comments on the PCNA in general.
It's heavy dust, settles fast.
To which projects and at what points in time does Section 504 apply? And the answer is Section 504 applies when a project or program receives federal financial assistance as defined in some detail in 24 CFR Part 8 and summarized in Appendix 3 to the proposed mortgagee letter. Section 504 requirements for new construction apply to all projects built with federal financial assistance after July 11th, 1988. All other assisted projects, including those that may have received or will receive assistance after their original construction, are subject to the requirements for existing housing in the regs at 24 CFR .8. And again, those are addressed in Appendix 3 of the mortgagee letter.
There are 3 consecutive questions here on site and practicality. They were originally related, but we separated them into 3 separate questions in order to deal with them more specifically. So for site and practicality, where an original site analysis was not done or can't be found, is there a post-construction test instead? Or can a current analysis of original conditions be used? The answer is no. There is no post-construction test of site impracticality. And the Fair Housing Act requires that the analysis be done as part of original design. However, for purposes of underwriting an application for FHA mortgage insurance where a claim of site impracticality is offered, the date when an analysis of site impracticality was or is conducted does not disqualify its use, provided that all the required topographic data, surveys, maps, and related materials describing the original undisturbed site and the project to be built are used in the analysis in accordance with the Fair Housing Act accessibility guidelines as illustrated on pages 1.38 through 1.58 of the Fair Housing Act Design Manual. So if you got all the evidence, you can show it. But that's the only condition in which a post-construction site analysis is going to be have any shot of success. Where slope exceeds 10% and is used to build a structure with 2 at-grade floors, does the excessive slope make this structure exempt from the fair housing design and construction requirements? Again, the answer is no. How come you get all the yes answers?
David, you're just kind of dour and negative. That's all there is to it.
Slopes in excess of 10% do not alone or by themselves exempt any particular structure or building from the requirements. The percentage of the buildable area measured in square feet of a site where the slope exceeds 10% is used to calculate the minimum percentage of the ground floor units at a project which must meet the design and construction requirements of the Fair Housing Act. But after this percentage is determined and the location and elevation of buildings entrances is identified on the site plan, the proposed site plan, then the individual building test must also be applied. Any additional units served by an accessible entrance must also meet the design and construction requirements, even when the addition of such units would exceed the minimum percentage. Incidentally, and notwithstanding any other condition of the site terrain, not less than 20% of all units in a non-elevator project must meet the design and construction requirements. The appropriate and required objective that the sponsor or owner should give to his civil engineer or his site planner is, in dealing with accessibility issues and challenging terrain, is to maximize accessibility. And 14, or the next question, whose responsibility is it or was it to review a site plan for site practicality? The local building official, the owner, the project architect, or civil engineer? Who? The answer, the owner and all participating design and construction professionals engaged in the design and construction of a project are jointly and severally liable for compliance with the design and construction requirements of the Act. A local public building official is not responsible for compliance or enforcement of the Fair Housing Act, and the local approval of proposed site plans does not determine whether the project meets the Fair Housing Act design and construction requirements and should not be relied upon.
That concludes the written questions, and that concludes our agenda. I just wanted to say thank you for all of you who participated, and I hope this has been a helpful session for you.